Hello, my name is Dick O'Regan. I'm with Mercer in San Francisco. We administer the State Bar-sponsored Lawyers Professional Liability Program. Lawyers Professional Liability Insurance is not required by the State Bar, but is strongly encouraged as a way to protect yourself and your clients should there be an error or an omission. Of course, if you form an LLP or a PC, the insurance is required. Now, the Bar has asked me to put together a list of 10 things to consider when you purchase professional liability insurance. The first is these policies are written on a claims-made basis. This means that the policy in force is the only policy that can pay a claim. When you first purchase a policy, the first policy will more than likely have a prior act's retroactive date. For example, if you buy a policy effective August 1, 2015, it will more than likely have a prior act's retroactive date of August 1, 2015. This means that the policy will cover claims reported during that first year only based upon acts that occurred after the retroactive date. Because of this, the premiums are relatively reasonable the first year. But each year's policy has to cover another year's worth of work or prior acts exposure, so the premium does increase each year until you reach the full prior acts or mature rate. Now, every carrier has a different schedule for their prior acts factors. Some carriers go up every year for 4 years, some max out at 5, some max out at 8 years. When you reach the full prior acts or mature rate, the premium should flatline depending upon, of course, changes in your practice or changes in the carrier's rate structure. Now, there's a number of things to consider when you look for prior acts, or for professional liability insurance. The first thing is the carrier admitted or non-admitted? An admitted carrier files their program with the California Department of Insurance. They file their rates and their underwriting criteria. They can only underwrite based upon this filing. In the event that you have a complaint against the insurance company, you can make a complaint to the California Department of Insurance, and they will advocate on your behalf. Also, in the event that the carrier goes bankrupt, becomes insolvent, the California Insurance Guarantee Fund will kick in to pay claims for an insolvent admitted carrier. A non-admitted carrier or surplus lines market does not file their program with the Department of Insurance. It's more of a buyer beware policy. SIGA will not apply. If you have a complaint, you cannot go to the Department of Insurance. There are, though, many fine surplus lines carriers offering coverage in California. And if you consider a surplus lines carrier, please look at the financials with your broker. Find out what their best rating is, how much surplus they have, before you make a decision to go that route. Another aspect you need to consider is how long the carrier has written coverage in California. Over the past 30 years, there's probably been 30 professional liability carriers who have entered the state and then withdrawn from the state after they've suffered severe losses. Normally, it takes 4 to 5 years for a carrier to determine whether or not they're making money in this product line, because it takes that long for the larger claims to go through the legal process. You want to deal with a carrier who has experience in dealing with this product. Another question you want to ask about is claims handling. Where is the claims staff? A lot of companies use claims staff that are based in the Midwest or New York. You really want to prefer to work with claims people in California, or at least in the same time zone, so you can get a quicker response to your matter. The initial contact with the claims department is very important. Now, most of the carriers end up using the same defense counsel, but your claims contact is important that they be lawyers, that they be experienced, and that they know what they're doing. Now, in terms of the policies itself, most lawyers' professional liability policies cover the same thing. They cover professional negligence as an attorney. But you need to ask the carrier or the broker about the exclusions in the policy that you're considering. Many policies have exclusions for securities work, entertainment work, copyright patent work, and there's a number of policies on the market today that have exclusions that eliminate coverage for any claim that originally emanated or began with a suit for fees. So if you don't sue for fees, you're doing okay. Another aspect, a very important exclusion in the policies, is every policy has an exclusion for representing a client where you have a financial interest. Now that financial interest could be 1%, it can be 10%, it all depends on the specific policy. But if you're doing a corporate practice where you may have some investments in your clients, you need to look at this exclusion very, very closely. Another thing you need to ask is what's the carrier's position regarding reporting incidents? Every company encourages their clients to report incidents, circumstances which could be expected to be leading to a claim in the future. Normally, companies will not penalize you for reporting these incidents. If you report it, they might set it up with a $20 reserve. Just it's on the books, and in the event it turns into a claim 3 years down the road, you've reported it, the carrier's on the hook for the claim. If you report many incidents, though, in a policy year, it could cause a red flag and cause a carrier to contact you and go, why did you report 6 incidents in the last month? But generally, you want to report it because if you don't report an incident, under the terms of the claims made policy, you didn't report it, it becomes a claim next year, you knew about it last year, you could have a coverage problem with the carrier. One other aspect is area practice. Now, when you look at an application, you'll see multiple areas of practice. The underwriter will ask you, what percentage do you do under criminal defense work? How much under workers' comp? The underwriters all acknowledge that these are estimates, they're best guess estimates. They understand that a small law firm, you can't predict year in, year out how your business is going to shake out. Now, the important thing to remember, though, is you don't want to intentionally misrepresent your area of practice. If you do, you could have a problem when there's a claim. Companies do rescind policies when they can prove that an insured misrepresented their practice to avoid paying the proper premium. 2 final points to consider is the policies written in California have defense costs within the policy limits, the so-called incredible shrinking policy, where every dollar paid for defense costs reduces the amount of money available to pay a settlement or an award. Now, many carriers offer an additional claims expense fund that can help you. You should ask your broker or the carrier, does the carrier have this fund? Can I buy additional claims expense limits? Because when you buy small limits, it limits the amount that the defense firm can pay or work to defend you. And the last issue, going through the life cycle of the policy, is the extended reporting provisions under the policy. Most policies have a provision that in the event you don't renew, either you decide not to renew or you're not renewed by the company, that you have an option to buy an extended reporting period, commonly called a tail. Tails are expensive. Now, many companies today have instituted a new provision that if you stay with the company for a certain number of years, 5 to 7 years, and you retire from the practice of law, they would give you a free tail. They would say that you've paid in, you've paid enough money, here's the endorsement, enjoy the rest of your life. And the last question we get is, should I use a broker? California is a unique state. There are a number of very qualified brokers who specialize in this product. If you choose to use a broker, I strongly advise you to use a broker who understands the business. This is not a product to go through your neighbor. This is a product you want to deal with a broker who understands the business and can help you get placed with the proper carrier. Those are my answers. Those are my questions. If you have any questions, please contact the State Bar at the numbers on the Cal Bar website. Thank you and have a great day.